Mr. Ramsey, do you want to get Officer McCarson and we can resume? We're on the record in T4DW 2021-1357, State of New Mexico versus Daniel Apodaca.
Renzi for the state, Your Honor.
And Christopher Molina on behalf of, and Molly Mahoney on behalf of Mr. Apodaca.
Okay, thank you. And parties, we have Officer McCarson still on the stand. Officer, you're still under oath.
Yes, Your Honor.
Mr. Molina, you were in the process of cross-examining Officer McCarson, and you were about to play a video.
Yes, Your Honor, just as a reminder for Officer McCarson and the court, defense had asked if there's, after Officer McCarson chose to arrest Mr. Apodaca, there was a moment where Mr. Apodaca says, "Now hang on a second," but nothing was made of it, and I'd like to play that portion for refreshment purposes.
And, okay, so if it's for refreshment, then I should probably step out. Would you like or are you all asking that the court step out, or are you going to be playing that at another time?
Your Honor, I don't
mean to cut you off. We would eventually be playing that. That's where the confusion's coming in. I'd be with Johnson, so.
If it's for refreshment, the court typically will step out and let you refresh the officer outside of the court's hearing.
And if we can just do that, Your Honor.
Okay, let me go ahead and step out, and I will be right back. I'll give you just a few minutes. Thank you. Okay, we're back on the record in T4DW 2021-1357, State of New Mexico versus Daniel Apodaca.
And officer, for the record, would you say your memory has been refreshed?
Yes.
Just so we're clear, after Mr. Apodaca steps out of the vehicle voluntarily, you said he's not going to do, he already refused field sobriety test and arrest, correct?
That's correct.
And he said, hang on a second while you were doing that?
That's what he said.
And you didn't, for clarification purposes, you didn't offer him field sobriety test when he...
I did not.
And Mr. Apodaca asked for a blood draw here, correct?
Yes.
One moment, Your Honor.
Sure.
Your Honor. You testified on direct, officer, that Mr. Apodaca refused a breath test.
Yes.
He said he would rather take a blood test.
He said he wanted a blood test done at the VA.
Okay. No further questions, Your Honor.
Yes, Your Honor. Officer McCarson, you're trained to use the NHTSA manual, correct?
Yes, I am.
How many pages is the NHTSA manual?
Objection, Your Honor, relevance.
State?
Your Honor, the defense proffered testimony from Officer McCarson about possible clues inside the NHTSA manual. The NHTSA manual is not one page, but hundreds upon hundreds of pages.
Okay,
So-
but what's your response to the objection?
Your Honor, the state is looking at the possible clues inside the NHTSA manual and asking the officer from his experience, since he's trained inside the manual, about said clues that were proffered by the defense.
Okay, defense?
Your Honor, I believe it also goes outside the scope of cross. We didn't ask how many pages the NHTSA manual was. We asked about specific clues. I believe the state's well within their rights to redirect on the specific clues we asked, but we didn't ask about how many pages the NHTSA manual is.
They did ask about the manual in itself, Your Honor.
Okay, I'm going to overrule the objection. I'll allow it. Go ahead.
And, officer, how many pages of the NHTSA manual, if you know?
Actually, I don't know how many pages it is. The manual itself is probably 2.5 inches thick.
And inside the manual, Officer McCarson, does it give you just one clue for bad driving?
No.
Does it give you 5 clues for bad driving?
No.
10 clues for bad driving?
No more than that.
So there's a plethora of clues possible for poor driving, that someone driving poorly on the roadway.
Yes.
Now, in this situation, did the defendant only drive poorly, make one mistake you observed?
Objection, Your Honor, asked and answered.
I'll rephrase, Your Honor.
Okay, so that's, questions withdrawn?
Yes, Your Honor.
Okay, objection sustained. Go ahead.
Officer McCarson, did the defendant drive poorly only one time?
Same objection, Your Honor. I believe the state went over this on direct examination.
I believe, Your Honor, if I'm not mistaken, the defense did talk about the possible clues in the driving of the defendant, and the state's redirecting the officer at this time.
And what's the objection?
Asked and answered that they went over what clues Officer McCarson observed on direct examination.
Okay, and give me a moment. I'm going to overrule the objection. I'll allow it. Go ahead.
Officer Carson, did you only see one clue of poor driving by the defendant?
No, I did not.
How many clues did you see?
Several clues. It would have been failing to maintain a lane multiple times, as I documented, twice to the right, twice to the left, making a wide right turn, slow to respond to the officers, to the emergency equipment to pull over, inconsistent signaling. So there were quite a few observations of poor driving.
And officer, when you first approached the vehicle, did the defendant show you his driver's license first?
He had it in his hand, but I didn't get it immediately.
And let's just move on a little bit to the defendant's breath. You said there was an odor of alcohol, correct?
Yes.
And where was that odor of alcohol coming from?
Objection, Your Honor, asked and answered.
Mr. Renzi?
Your Honor, I'm asking, I asked where the odor of alcohol was coming from Officer McCarson. My first question was, there was an odor of alcohol. Odor of alcohol, as defense has stated, could be anywhere inside the vehicle, and redirecting Officer McCarson as to where it's coming from.
And I think the objection is to ask and answer. What's your response to that?
It's not asked and answered, Your Honor. I'm asking a separate question. That's why I'm confused on what the objection is.
Your Honor, this was all went over on direct examination. It just seems like it's an attempt to bolster the clues that Officer McCarson has already testified to.
Response to that, Mr. Renzi?
It would be bolstering, Your Honor, if these weren't things that were brought up in the cross by defense, Your Honor. I'm not
Okay, I'm going to sustain the objection. I recall hearing the same testimony.
Okay, understood, Your Honor. Officer McCarson, do you recall it was windy that night?
Just raining?
And do you recall there's any smoke coming from the vehicle?
No.
Any
No.
dust in the air?
No.
Objection, Your Honor. Outside the scope of cross-examination.
I don't believe that's outside the scope, Your Honor. If I'm not mistaken, on cross-examination, defense went into how eyes could be bloodshot, and I'm giving other possibilities to what's there. As we can see, there's no wind that night, and there's no smoke coming from the vehicle.
Okay, I'm overruling the objection. Go ahead, Steve.
Officer McCarson, how many times did the defendant refuse to do field sobriety tests, to your knowledge?
Twice to me.
Just to you. And I believe you said 3. Where would the third time come from?
Objection, Your Honor, calls for hearsay.
I'll withdraw the question, Your Honor. No further questions.
And are we done with Officer McCarson? State, do you need to reserve him?
State does not need to reserve him at this time, Your Honor.
Okay, defense, you want to reserve Officer McCarson for rebuttal?
No objection, Your Honor.
Okay, and so, we can go and excuse Officer McCarson for the day?
Yes, Your
Yes, sir.
Okay, so you're excused, officer. You may stay if you'd like.
Thank you, Your Honor.
State, are you ready to call your second witness?
Yes, and my second witness would be Sergeant Brian Johnson, Your Honor.
Okay. Good morning, Sergeant. Please raise your right hand. Do you swear and affirm that the testimony you're about to give is the truth under penalty of perjury?
I do.
Thank you. Please have a seat. Make yourself comfortable. Make sure the microphone is either close to you or that you speak loudly. Thank you.
May I state procedure, Your Honor?
Sure.
Thank you. Please state your name for the court.
Brian Johnson.
And where are you employed?
I'm a full-time sworn and salary commissioned sergeant with the Albuquerque Police Department.
And how long have you been in law enforcement?
Approximately 12 years.
And how are you currently assigned?
I'm the sergeant of the DWI unit.
And Sergeant Johnson, were you on duty on October 1st, 2021?
Yes.
What were your duties on that date?
I was, I believe I was working the NDWI grant. which is a traffic enforcement, and you take the position of a DWI officer.
And were you, what were you wearing on the date in question?
I was displaying my official badge of office in a official uniform in a marked patrol, or actually it was an unmarked patrol unit in the city of Albuquerque, County Bernalillo, state of New Mexico.
Did you come into contact with anybody in the courtroom today?
Yes.
Who'd you come into contact?
Daniel Apodaca, who's wearing the, looks like green plaid shirt.
Mr. Apodaca, please put your mask down for a moment for identification purposes. And is that the individual, Sergeant Johnson?
Yes.
Okay.
And Your Honor, would the court please note the officer has identified the defendant at this time?
The record will so reflect.
And where did you come into contact with the individual?
On 10/01/2021 at 00:15 hours, I was dispatched to Tim McCarson's traffic stop. He had mentioned that there was an individual that did not want to step out of the vehicle.
And what did Officer McCarson tell you?
Objection, Your Honor, calls for hearsay.
Your Honor, based on the police team concept, this wouldn't qualify as hearsay. As we just heard from the testimony of Sergeant Johnson, he was called to the scene. This is going to be his recollection. Additionally, we've had Officer McCarson testify, and we have a video that's going to be played on the matter as well, Your Honor. So this won't be hearsay as stated by the defense.
Anything further from defense?
Yes, Your Honor, this is an out-of-court statement. This would be an out-of-court statement made by Officer McCarson as to, and the state is offering it for the truth of the matter asserted. I believe it could be, question could possibly be rephrased a different way, so where it's not hearsay, but the way the question's phrased calls for hearsay, Your Honor.
And Your Honor, at the same time, one of the exceptions is an officer being under oath and testifying, and that's what Officer McCarson did, and Officer Johnson is currently doing as of right now. So that would be the state's response at this time, Your Honor.
The objection is overruled. The court will allow it. This is allowable to establish the police team concept. Go ahead.
You came into contact with Officer McCarson. What did he tell you about the stop?
I don't remember the exact details, but he had basically said that he observed a signs of intoxication and that he was that he needed help getting the individual out of the vehicle. And
what, did the individual, when you made contact, freely get out of the vehicle?
At first, no. I observed he had bloodshot, watery eyes, a strong odor of alcohol emanating from his face region, as well as slurred speech.
And did he have his window down at this time?
Yes.
How far down did the defendant have the window down?
I don't remember exactly how far down.
And do you know if Officer McCarson had a lapel camera at that time?
Yes, he did.
And Your Honor, the state would like to publish the portion of the lapel video with Officer McCarson and Sergeant Johnson.
Okay, defense?
No objection, Your Honor.
Okay, and have you all previously discussed the portion that is going to be played?
And Sergeant Johnson is on the stand to testify to anything that he may have said on the time, so defense doesn't have any objections to the, I believe it was about 5 minutes? Yeah.
Okay, so do you need to have Sergeant Johnson identify the video before it's published? It's not his video, it's Officer McCarson. Okay, go right ahead.
Video.
Sergeant, can you see the video?
Yes, I can.
Okay.
Sergeant Johnson, did you, offer field sobriety test to the defendant?
I did not.
But did the defendant make any statements about not taking field sobriety test?
He said that he did not want field sobriety tests.
And at any point in time, did, you raise your voice with the defendant?
I did not.
And you just remained calm the entire time with your interaction with the defendant?
Yes.
And what was the next step in your part of the investigation after the defendant was removed from the vehicle?
I had no other involvement.
The state has no further questions at this time, Your Honor.
Okay, thank you. Defense?
Yes, Your Honor. How are you, Sergeant?
How you doing, sir?
Good. If at any point you can't hear me, just ask me to repeat a question. Is it fair to say you were called out on scene about 8 or so minutes after the initial contact with Officer McCarson?
I believe so. I was dispatched at 0015 hours.
And did you arrive on scene at about 0020 hours?
That is correct.
Okay. After you spoke to Mr. Apodaca, he got out of the vehicle on his own, right?
Yes, he did.
You didn't have to place your hands on him at all?
I did not.
Okay. You didn't have to use any service weapon or anything like that?
I did not.
You didn't have to break his window?
I did not.
Okay. And you did not offer field sobriety tests, right?
I did not.
Your Honor, one moment to confer with co-counsel.
Sure.
Officer, Sergeant, did you just testify that you observed bloodshot, watery eyes?
A strong odor of alcohol emanating from his face region as well as slurred speech. Yes.
And you testified to all that on direct examination?
Yes.
You took a, you did a pretrial interview in this case, correct?
I'm not sure if I did.
If I played a short clip of that pretrial interview, would that refresh your memory that you did take one?
Yes.
And, Your Honor, permission
Would you like me to step
play,
out?
just for a brief moment, Your Honor.
Sure, I'll step out for just a moment, and I will just be right outside the door.
Thank you. Thank you, Your Honor.
Okay, we're back on the record?
And just for the record, Sergeant Johnson, has your memory been refreshed?
Yes.
And so you did do a pretrial interview in this case?
Yes, I did.
That was on or about February 2nd of this year?
Yes.
Okay. And in this pretrial interview, isn't it true that you stated that you observed no odor of alcohol?
I don't remember. I do know that I did do a pretrial, but I don't remember exactly what I said.
Your Honor, I would ask to play about 30 seconds of the pretrial interview for impeachment purposes.
Okay, state.
No objections at this time.
Okay, go right ahead. Is there some kind of identifier before the portion you're going to play, or how do we know this is from this specific case?
I can play a short identifier for the record and for the court, Your Honor.
Okay, yeah, I just want to make sure, because I'm sure Sergeant Johnson does a lot of PTIs for other cases as well.
Speaking as Vanessa Hidalgo, defense attorney. Today's case is State versus Daniel Apodaca, case number T4DW 2021-001357. With me is
Sergeant Johnson, APD.
And Your Honor, is that sufficient for the court?
State? Okay, yes, the court's satisfied, thank you.
Okay.
step out.
Probably 2 minutes.
And was there anything that you personally observed from him? Any the odor? Okay. And when he got out of the vehicle, you didn't notice anything, about him?
I wasn't really paying attention.
And officer, isn't it true in your pretrial interview you said you did not notice an odor of alcohol that night?
Yes, it sounded like I was there for, taking him out of the vehicle.
Even though you were there to take him out of the vehicle, you did not notice an odor of alcohol?
I did not mention bloodshot, watery eyes, strong odor of alcohol emitting from his facial region as well as search speech. Doesn't mean that I didn't see it at the time,
And
but in this,
when, in this pretrial interview, when you were asked if you noticed anything, you did not say bloodshot, watery eyes. Is that correct?
no, I did not. I just told I told her that I was there for taking him out of the vehicle.
Okay. And just for the record, you did not say anything about slurred speech during this interview?
No, I did not.
Okay.
I told them that I was there to take the person out of the vehicle.
Okay. And you didn't complete any written documentation in this?
I did not.
So this is the first time we're hearing about bloodshot, watery eyes, slurred speech?
This is an observation that I saw, yes.
Okay. And you didn't notice it? You didn't personally notice anything in the vehicle?
I did not.
Your Honor, may I have one more moment?
Sure.
No further questions.
Redirect?
Just a few questions.
Okay.
Mr. Johnson, is extraction of a possible defendant the standard for APD?
For a potential DWI, yes.
And why is that?
Okay, I'm sorry, repeat the question again?
Is extraction of a possible defendant standard protocol for APD?
Okay.
Your Honor, I would object here to 403. That is a confusing question. It could be misleading. And I believe it's also outside the scope of cross, Your Honor.
I'll withdraw the question, Your Honor.
Okay, and so the objection is sustained.
Sergeant Johnson, you noted an odor of alcohol, correct?
Yes.
And slurred speech
Yes.
and bloodshot, watery eyes, correct?
Yes.
Your Honor, objection, same objection as the previous officer asked and answered. It has been established that the state has asked all these questions of Officer Johnson.
Let me take a look at my notes, but I'll hear a response from the state.
Yes, Your Honor, I'm redirecting Officer Johnson as to what he saw. We don't have a written report. All we have is the pretrial interview. So as this is a redirect, the state is just following up and has follow-up questions to that as well.
Okay, I'm going to overrule the objection. I'll allow it. Go ahead, state.
And as stated before, you stated that you noticed bloodshot, watery eyes, slurred speech, and an odor of alcohol, correct?
Yes.
And you filed no report, correct?
I did not.
And how long have you been conducting DWI investigations? Your Honor, this goes to the training and experience of Officer Johnson. If he was a rookie in 1 year, I would understand for him not to be able to note such clear clues, but his training and experience and seeing that defense has delved so deeply into it, it is crucial on redirect to get his training and experience and his knowledge in on those factors that he can observe.
Training or experience question.
Okay, and state your response.
But they did, Your Honor, go into the details of Officer Johnson, asking him. This is all going to pertain to his training and experience, just by asking him about bloodshot, watery eyes, training of alcohol, odor of alcohol and slurred speech. Civilians do not have that specific training, Your Honor. So they're questioning the officer on it is going to go to his training and experience.
I'm going to overrule the objection. I'll allow it. Okay, let's get closer to the microphone so we make sure you are on the record. Go ahead.
Your Honor, just for the record, I understand the court's ruling, but I'd make a standing objection to further questions here as defense asked what defense did not even ask what Sergeant Johnson observed, just that he testified to something on direct and he testified to something, and he said something different in his pretrial interview. We didn't come close to asking about training or experience.
Okay, your objection is noted, and you've made your argument for the record. Thank you.
Thank you, Your Honor.
Sergeant Johnson, how long have you conducted DWI investigations?
Since I've been a police officer, which is about 12 years.
So in 12 years, you've noticed bloodshot, watery eyes
Yes.
and smell of alcohol? Yeah.
Same objection. Not only is this asked and answered, but this is unduly cumulative at this point. It just seems like the state is finding different ways to mention over and over again what Sergeant Johnson may or may not have noticed on that night.
Mr. Renzi?
Your Honor, at this time, the state will withdraw that question. Just one final question, Your Honor.
Okay, go ahead.
Then. Actually, no further questions, Your Honor.
Okay.
Thank you.
Thank you. And State, are we done with Sergeant Johnson?
The state will not be reserving the sergeant anymore.
Okay, would the defense like to reserve?
No, Your Honor.
Okay, Sergeant Johnson, you're free to leave or to stay. Thank you. Does the state have any other witnesses to call?
Yes, Your Honor, one more witness.
Okay,
He's on the hall right ground.
okay. Okay, and what's the name of the witness that you're calling?
Brian Wilson, Your Honor.
Okay. Officer, please raise your right hand. Do you swear and affirm that the testimony that you're about to provide is the truth under penalty of perjury? I do. Thank you. Please have a seat and make yourself comfortable. And make sure the microphone's pulled close or that you speak loudly.
Good afternoon, officer. Can you please state your full name for the court?
Officer Brian Wilson with the Albuquerque Police Department.
And Officer Wilson, how long have you been employed with the APD?
It'll be 4 years this May.
Are you full-time sworn salary commission peace officer?
I am.
And how are you currently assigned?
To the Field Services Bureau of the Northeast Area Command.
And what were your duties on October 1st, 2021?
To respond to calls for service.
And did you respond to a call to service that day?
I did.
And what were you wearing on that day?
The same uniform I'm wearing now, Field Services Bureau uniform, displaying my badge of office.
And what were you driving on that day in question?
A fully marked police vehicle.
And did you come into contact with anybody in the courtroom?
I did.
And who did you come into contact with?
The gentleman in the dress shirt wearing glasses at the defense table.
Mr. Apodaca, please remove your mask for a moment for identification purposes. Thank you. And officer, is this the same person?
Yes, Your Honor.
Okay, thank you.
Your Honor, would the court please note that the officer has identified the defendant?
The record will reflect that. Thank you, Mr. Apodaca.
And what happened when you arrived on scene?
I arrived on scene as backup for DWI Officer McCarson. He requested an additional officer. When I arrived, I saw he'd stopped a silver sedan. I approached on the passenger side and looked in with my flashlight. I saw the defendant behind the
State?
I'll make sure to break it up, Your Honor.
Okay, so the objection is sustained. State, please ask a question. I think Officer Wilson just going straight into narrative without a question being asked.
Understood, Your Honor. And officer, you said you approached on the driver's side. When you looked inside, what did you see?
I approached on the passenger side.
Yeah.
I saw a male behind the driver's seat, the defendant, and I also saw beer cans behind the driver's seat and on the floorboard of the front passenger seat.
And what else? What happened next in the investigation?
Officer McCarson seemed to be trying to get a dialogue with the driver.
Objection, Your Honor, calls for speculation.
And
State?
Your Honor, the state withdraws that question.
Okay. The objection is sustained. Questions withdrawn. Move on, please.
No problem, Your Honor. And Officer Wilson, what was your role in the investigation of the defendant?
For the investigation?
Yes, for the investigation.
I had no investigative purpose. I did a tow sheet.
Okay. And what did the tow sheet reveal for you? What did you put on the tow sheet? Excuse me.
The registered owner of the vehicle that was stopped, and all the information for the vehicle that was stopped for the tow company.
And anything else?
That's it.
Did you do an inventory log of the vehicle?
I did.
And what did you put in the inventory section?
To my memory, I believe I put miscellaneous personal items, possibly beer cans. I don't remember.
Your Honor, may I approach, please?
Are you asking to refresh the officer's recollection?
No, Your Honor, I actually do have the tow sheet.
Oh, okay. Defense, was there an objection?
I didn't know what the purpose was. So you're just trying to...
May I approach, Your Honor?
Yes.
Also, I just handed you something. What is this?
This is the tow sheet that I completed for the incident.
And how do you know that you completed for this incident?
My signature is on the bottom, adjacent to my man number, on the bottom of the form.
Your Honor, the state would admit State's Exhibit 2 into evidence.
Defense?
And, Your Honor, defense would only object to it being cumulative at this point, as we have heard from multiple officers about the contents. I believe it serves no probative purpose here, and it's substantially outweighed by unfair prejudice.
Okay, State?
Your Honor, the State's bringing their case the way that they see fit, and this time I don't believe it's prejudice or cumulative. I believe the fact of the open containers in the vehicle and the amount of containers are very important to this case.
Anything else from defense?
And, Your Honor, the state has mentioned that the amount of beer containers are important here, but there's nothing that says anything about amount on the tow sheets. I believe it's just unduly cumulative at this point.
Okay, I'm going to overrule the objection. I will allow it. Defense will have an opportunity to cross-examine Officer Wilson. Go ahead.
And, Your Honor...
And State's Exhibit number 2 will be admitted.
Okay, thank you. And Officer Wilson, again, looking at the tow sheet, what did you note as the items for the inventory?
Under the contents box, I noted a cell phone charger cable, clothes, and beer cans.
And cans is plural. Do you remember how many beer cans there was in that vehicle?
Specifically, no, but there were multiple.
Multiple. And do you remember where these beer cans were located?
Yes, behind the driver's seat on the floorboard and in front of the front passenger seat on the floorboard.
Yes, please take a look at that before I'll give this back if you want to use this, Mr. Molina. Let me just take a quick look. Molina, it's here if you'd like to use it.
Good afternoon, Officer Wilson.
Good afternoon.
If you can't hear me at all because of the mask, just ask me to repeat myself.
Okay.
You stated that you approached on the passenger side.
Yes.
Safe to say the window was rolled up?
My memory.
Okay.
Yes.
And your primary role is backup officer here?
Correct.
And isn't it true you couldn't hear what the conversation was?
Correct.
You didn't speak to the driver at all?
I did not.
Okay. No further questions, Your Honor.
Correct. Okay, and may we excuse Officer Wilson?
Yes, Your Honor.
Does anybody want to reserve him for rebuttal? Okay. Thank you. And Officer Wilson, you're excused, but you can stay if you'd like as well. Thank you. Does the state have any other witnesses to call?
No, the state rested this time, Your Honor.
Okay. And defense, do you have a motion?
Yes, Your Honor. We've moved for a directed verdict at this time.
Okay, go ahead.
Defense is making a motion for a directed verdict here, Your Honor, on all charges. We'll go through it individually, but defense does not believe that even in light most favorable to the state, that there is sufficient evidence for this case to go forward, Your Honor. And we'll start with the failing to maintain lane, Your Honor. There's no evidence of the failure to maintain lane visually. We heard from Officer McCarson that I believe it was twice on each side, but failing to maintain lane, Your Honor, does not require to be exactly in the lanes at all times. If Officer McCarson had lapel video, we could see that. The statute says a vehicle shall be driven as nearly as practicable entirely within a single lane, and shall not be moved from such lane until the driver is first ascertained that such movement can be made with safety. As to the second part, there's no testimony that these alleged failing to maintain lanes were done in safety, Your Honor. There's no testimony that there is any vehicles around. There's no testimony for how long or how wide he may have crossed the lines. It could have been just briefly, Your Honor. And I believe in State versus Siqueiros Valenzuela, 2017 NMCA 074. In that case, the defendant's left tires touched the lane, and this momentary touching of the shoulder did not constitute a violation of the statute. And, Your Honor, as nearly as practicable, it was raining. It was established that Mr. Apodaca struggles with his eyesight, and he was trying to maintain lane as nearly as practical. So we'd ask that you grant the motion for a directed verdict on that charge. And then, Your Honor, I believe the open container charge is charged under 66A-138, or 66-8-138A, says no person shall knowingly drink any alcoholic beverage while in a motor vehicle upon any public highway within the state. Your Honor, there's no testimony as to consumption of alcohol. Nobody witnessed this. There was no admissions being made. There's no evidence of drinking or consuming any alcoholic beverage, even knowingly, Your Honor. So we believe that the state has failed to meet their burden at that point, and we ask for a directed verdict on that charge as well. And then finally, the DWI, Your Honor, we'll break it up into two pieces. First, we believe the aggravated portion, there is not enough evidence here that the state provided to move forward, even in light viewed most favorable to the state. We heard testimony that Mr. Apodaca wanted a blood test. A blood test can accurately measure the alcohol contents of your blood. It would be arguable that it's better to do a blood test than a breath test, Your Honor. And the Implied Consent Act says any person who operates a motor vehicle shall be deemed to have given consent to chemical tests of his breath, or blood, or both. Now, obviously, it has been changed that you cannot no longer give your implied consent for a blood test. You have to give a verbal consent for a blood test, and that's what Mr. Apodaca did in this case, Your Honor. It was Officer McCarson's discretion that he didn't want to give him a blood test, so he counted it as a refusal. And then for the simple DWI portion, we do not believe the state has met their burden here, Your Honor, even in light most favorable to the state, as a blood blood test was not conducted, even though Mr. Apodaca consented to one and wanted one. So we don't actually know what the alcohol contents of his blood were. So we look at the totality of the circumstances. I'm sure the state's going to argue that he failed to maintain his lane. He explained to the officer multiple times that he was having trouble seeing during the rainstorm, that the rain was messing with his vision, and he was trying to do so. He was still trying to maintain lane as practical as possible. Same thing applies for when Officer McCarson activated his lights. It is still hard to see, and Mr. Apodaca did pull into a parking lot safely. Was not going to strike a vehicle there, Your Honor. So we would say those are in itself not indicative of impairment here, Your Honor. The state mentioned, and Officer McCarson confirmed, there's not just one cue in the NHTSA manual. There are many cues, and as far as we can tell, there was one cue of bad driving, which is failing to maintain lane. There was no evidence of him driving the wrong way, no evidence of him almost striking a vehicle. He was operating his headlights. It just simply was hard for him to drive home in the rainstorm, Your Honor. So we look at other clues. There's no admissions to drinking, and the state's gonna most likely equate not wanting to get out of the vehicle with refusing field sobriety tests. But Your Honor, we watched the video. It's unclear, as he was never actually asked, will you do field sobriety tests? Multiple times Officer McCarson said, I need to investigate. And in a response, Mr. Apodaca says, I'm not getting out of the vehicle. He gets out of the vehicle voluntarily. I know it takes a while, Your Honor, but he did mention he was a disabled veteran, and we do not know the extent of why he's disabled, if it's physical disablements where he was not able to do field sobriety tests, if he is suffering from some sort of mental health condition from his military time. For example, PTSD might make someone not want to get out of the vehicle when there's someone with a weapon demanding you get out of the vehicle. We're not trying to make excuses for him, Your Honor, but that could have been a reason why it took some time to convince him to get out of the vehicle, which he ultimately did on his own volition. Officer McCarson said multiple times he wanted to investigate, but after Mr. Apodaca got out of the vehicle on his own volition, Officer McCarson arrested. He didn't ask about field sobriety tests specifically there. He said he deemed their conversation as a refusal and arrested Mr. Apodaca, even though Mr. Apodaca, it seemed like he was saying, hang on a second, and we don't know what he was going to say at that point. Maybe he did want to take field sobriety tests now that he was out of the vehicle, that he felt comfortable to do so. The signs that were mentioned, Your Honor, the smell of alcohol. Officer McCarson testified that the window was open about that much. And we could see from the lapel video that Mr. Apodaca was not putting his face up against the window, so it was impossible to tell where that smell was coming from with such a small crack in the window and Mr. Apodaca not putting his face near the window. It could have very well been from the open container in the driver's side door, Your Honor. It was right underneath it that could have easily given the smell of alcohol. In terms of slurred speech, you heard the lapel video, Your Honor. We do not believe, we believe the lapel video there speaks for itself. We don't believe Mr. Apodaca was slurring his speech, and there was no way for the officer to know if that's just the way he talks, if he had any speech impediments. And then, Your Honor, in terms of bloodshot, watery eyes, there are many reasons, or bloodshot eyes, excuse me, there are many reasons that one can have bloodshot eyes, including crying. It was after midnight. And Officer McCarson agreed to that. Now we heard from Officer Johnson today for the first time in this investigation that he noticed bloodshot, watery eyes, slurred speech, and an odor of alcohol. Despite him saying in a pretrial interview in February, where he agreed, or he knew he was being recorded, that he did not observe any signs of intoxication. That wasn't his role. He wasn't paying attention. If the alcohol, the odor of alcohol was as strong as Officer McCarson said, Sergeant Johnson would have answered it like that in the pretrial interview, Your Honor. He would have said odor of alcohol, but it seems like today, for the first time, he's throwing in odor of alcohol for whatever reason. Throwing in bloodshot watery eyes. He's throwing in slurred speech, the kind of de facto signs that an officer says they noticed, despite him having an opportunity to say what he noticed specifically in terms of signs of intoxication in that pretrial interview, and he said nothing. He said he did not notice anything. He was not there to investigate. And he did say he did not offer him a standard field sobriety test either, Your Honor. So in conclusion, all we have, we don't have alcohol. There is no admissions. We don't know what would have happened in the standard field sobriety test because Officer McCarson did not ask Mr. Apodaca after he got out of the vehicle. And we have alleged bad driving that can be explained away by the conditions of the rain that night and Mr. Apodaca's eyesight, Your Honor. So we believe, taking all that into consideration, the state has failed to sufficiently meet their burden at this stage, Your Honor. It seems like this case is a puzzle. There's many puzzle pieces missing, and the state's going to ask you to fill in those puzzle pieces for them, Your Honor. So we'd ask that you grant your motion for directed verdict.
Thank you. State.
Your Honor, the evidence is in light of most favorable to the state. So the state will start very briefly with count 4, the open container. As we heard from testimony from Officer McCarson, and we've seen in the video, when the door is open, we see an opened cold beer with liquid still in it, within reach of the defendant. And I'm not speaking about the beers that were in the passenger side, or behind the defendant, behind him, open right there. Officer McCarson also stated the strong odor of alcohol. He just didn't say odor, the strong odor of alcohol. Additionally, this is the defendant's vehicle. He's driving. He knows what's in there. The odds that there is a cold beer sitting next to the defendant, open next to him, and it's just sitting there and driving around, the state would argue is irrelevant. No one leaves open containers of alcohol in their vehicle.
Your Honor, I hate to have to object, but I believe that's a mischaracterization of evidence. I don't believe it was ever established that it was Mr. Apodaca's vehicle, just that he was the driver of the vehicle.
State.
I believe it was on the tow sheet, Your Honor, if I'm not mistaken. It does state that it is his vehicle. The registration information is on there.
Okay, and your objection is noted, but I believe that I heard Officer Wilson say that the vehicle was registered. I could go back and look, but the court will not be giving that very much weight in its consideration. But please move on, Mr. Renzi.
So additionally, Your Honor, with that count, the person shall knowingly drink alcohol, an alcoholic beverage while in a motor vehicle upon any public highway. The state would show that we do have the sufficient amount of evidence to move forward at this time and survive the directed verdict, Your Honor. Second, the failure to maintain traffic lane. Officer McCarson did state that the defendant went to the left twice and to the right twice. And this was concerning enough for him to want to stop the defendant. And Your Honor, his report's pretty clear, and so is his testimony about the poor drive in this situation. As the defense has pointed out, the statute does say any vehicle shall be driven as nearly as practicable entirely within a single lane and shall not be moved from such a lane until the driver has first ascertained that such movements can be made with safety. Your Honor, this wasn't the defendant driving safely in the lane. This was concerning enough for the officer to stop the defendant, and he gave testimony as such. Further, Your Honor, let's move to the more pressing matter, which is count 1, the aggravated portion. The state is going to establish and show, as they did today, for Your Honor, to survive this verdict, that there was more than enough information here, more than enough evidence. First, Your Honor, this happened in the state of New Mexico on or about the 1st of October 2021. That's not contested here. I believe what's contested is whether the defendant, one, agreed to the standard field sobriety test. not only did he refuse, saying before Officer McCarson could ask that he wasn't going to do it, when Officer Johnson again stated that the way that I can tell if you're intoxicated or not is for you to do standard field sobriety test, the defendant again said no. It is not the officer's job to convince an individual over and over again to, one, exit their vehicle after a lawful order is given, and two, for them to do the standard field sobriety test. As Officer McCarson has stated, he didn't arrest the 3,000 to 5,000 people, every single one of them that he pulled over, Your Honor, and I think that also goes to the portion of when the defense brings up the blood test. Officer McCarson offered a breath test. It is only after the first initial test is complete that the second subsequent test that the APD would pay for would be done. It is at this time where there was a refusal. He was not going to do the first initial test. The officers control their investigation. We do not let a defendant or somebody who gets pulled over decide when they get out of a vehicle, what they do, if they're going to do them or not. He did. He refused him. He refused the standard field sobriety test. He refused the breath test. This was all stated by Officer McCarson. We even have Officer Johnson who had to be called on scene to have the defendant exit his vehicle. Because I'll tell you this, Your Honor, there's no way that standard field sobriety test can be conducted if somebody is inside of a vehicle. The defendant chose that himself. So that portion, the defendant refusing to submit to a chemical test, is equivalent to the refusal of the standard field sobriety test. State v. Wright makes it clear, Your Honor. We see no meaningful distinction between evidence of a defendant's refusal to take a breath alcohol test and evidence of a refusal to do standard field sobriety tests. And further, Your Honor, McKay versus Davis, the court stated this: a defendant's refusal to take a chemical test is relevant to show his consciousness of guilt and fear of the test results. We know that the defendant operated the vehicle, Your Honor. Officer McCarson was behind him. We also know that the defendant, at the time, was not operating that vehicle safely, and that there was a reason the windows weren't rolled down and why he did not exit the vehicle. The state, through its evidence today, has shown that the defendant is guilty of these counts, but we ask that you deny the defendant's directed verdict at this time, Your Honor.
Thank you. Any follow-up from defense?
Just briefly, Your Honor. Just in terms of responding to the state's argument, they say there's no way that you can do standard field sobriety tests while inside of a vehicle. That is true, but Mr. Apodaca was not offered standard field sobriety tests when he got out of the vehicle on his own, voluntarily. And then the case that the state cites that says refusal could be a consciousness of guilt, that you're afraid of the test results. Mr. Apodaca immediately wanted a blood test. That doesn't show to defense that he was afraid of test results. That shows that he's afraid of if there would be no blood test results here. There's no other more accurate way to test someone's blood than a blood draw, which Mr. Apodaca wanted and the officer refused. We would just renew our motion at this time.
Thank you. Okay, on defense's motion for directed verdict, the court is going to find that there is sufficient evidence to move forward on the open container charge based on the evidence that the court heard. Regarding the failure to maintain lane charge, I believe at this stage, in the light most favorable to the state, there is enough evidence to move forward on the failure to maintain lane charge as well. As to the aggravated portion of the DWI, the court believes there is sufficient evidence to proceed in the light most favorable to the state. As to the DWI charge itself, the court believes there is enough evidence to proceed to the beyond a reasonable doubt standard in the light most favorable to the state. So those are my rulings on those three charges. I'm not expanding on those at this time because I want to give more of a justification at the, after I've heard more argument at the beyond a reasonable doubt standard if defense wants to put on their case. Do you want to, does defense want to, present a case to the court? Sure, sure. And, we'll pause at this point. We'll go off the record. Parties, we are back on the record in T4DW 2021-1357, State of New Mexico versus Daniel Apodaca.
Forensic for the state, Your Honor.
Christopher Molina and Molly Mahoney on behalf of Mr. Apodaca.
Okay, and Mr. Molina, Ms. Mahoney, the court gave you some time to speak to your client, and does defense want to put on a case?
No, Your Honor, defense rests.
Okay, so at this point, I'll give parties a chance to give their final closing argument. State, you'll go first. Go ahead.
Thank you. Your Honor, we're here today for multiple counts in this case. One is the aggravated DWI charge, the second being the failure to maintain lane, and the third being the open container charge. I'll start with the open container charge. We saw from video today and testimony that there was an open container within the reach of the driver on the driver's side door. I guess it would be a little cubby. Officer McCarson, inside in the video and even in his report, says that it's a cold 16-ounce Bud Light. Your Honor, this is within reach of the defendant. He can reach it, consume it. But not only that, it's not like there was just one can of alcohol in there. On the passenger side floorboard, we have another case of alcohol that was noted and shown in the video that it's opened. And additionally, behind the driver, there's another case of alcohol that is opened within arm's reach if he was to reach behind himself. Your Honor, the statute is quite clear for the open container charge. No person shall not only drink any alcoholic beverage while in a motor vehicle upon a public highway within the state. Your Honor, this is a cold beer within the reach, and Officer McCarson's statement was, it's not just an odor of alcohol, it's a strong odor of alcohol emitting from the defendant. This is also the defendant's car, as we've seen from the tow sheet, with his registration on it, as noted by Officer Wilson. So, Your Honor, the state does believe that they've met the burden of proof for the open container charge. Your Honor, moving on to the second count, which is failure to maintain traffic lane, Officer McCarson stated himself that the defendant went to the left, crossed the line, and to the right. This was concerning enough for him to have to activate his emergency lights and attempt to pull over the defendant. Because of his bad driving and because he was not complying with the laws and regulations of the state, Your Honor, the failure to maintain lane, it simply states, whenever a roadway has been divided into two or more clearly marked lanes for traffic, the following rules, in addition to all others consist here within, shall apply. A vehicle shall be driven as nearly as practical entirely within a single lane and shall not be moved from such lane until the driver has first ascertained that such movement can be made within safety. Your Honor, Officer McCarson stated that the defendant went to the left twice, went to the right twice. This is not safely driven. As the wording states, it's practically, as nearly as practical entirely within a single lane. That is middle, that is as close as you can. Regardless of the defendant's vision or his capability of driving, as he stated several times by his own admission, he has a problem seeing and it's raining. If it's that concerning, he shouldn't have been driving at that time, Your Honor. Hence why Officer McCarson took his stance of pulling over the defendant for him failing to maintain his lane. The state does believe at this time, Your Honor, based off the facts and evidence, that they have met this burden. But to the more concerning charge, Your Honor, which is count one, the aggravated driving while under influence charge, this did happen in the state of New Mexico on or about October 1st, 2021, as outlined by Officer McCarson, his report, Sergeant Johnson, and also Officer Wilson, who also said this happened within the state of New Mexico and on October 1st, 2021. I'll just start from the very beginning. Officer McCarson did witness the operation of the motor vehicle, so that element's met, same with the location, Your Honor. And at the time the defendant was under the influence of intoxicating liquor, Your Honor, the state will renew again the consciousness of guilt and bring this to the court's attention, where the defendant had refused to submit to a chemical test. His refusal was clear, Your Honor. And as State v. Wright states, we see no more meaningful distinction between the evidence of a defendant's refusal to take a breath alcohol test and evidence of refusal to take standard field sobriety tests. I bring this particular situation up because the defendant wanted to go to the VA, but Your Honor, we don't know if the VA was open at that time, if this was possible. There's something very particular about alcohol, and it is this: it disappears over time. People go from drunk to sober. That's how it works. Postponing the breath test would have given the defendant a benefit, but that's not how this works. Officer McCarson read the Implied Consent Act, that the defendant give the breath test, and then he is allowed to get an independent test after, in which APD would pay for. That's not what he wanted. But in this situation, Your Honor, it wasn't at a point where it's what he wanted, because as we see from the entirety of this matter, the defendant did exactly what he wanted. He refused to get out of the vehicle when a lawful order was given, to the point that a sergeant had to be called on scene to ask him to leave the vehicle. Additionally, the defense wants to make it seem that the defendant left the vehicle freely without any issues. Your Honor, that's not so. Why would a sergeant be called on scene? He refused, even saying, look, leave me here, my wife will come and pick me up. That's not how this works. A lawful order was given by an officer for him to exit the vehicle. He refused to roll down his window the rest of the way. And what do we see after, finally, when the defendant leaves? An open can of alcohol within arm's reach, two more cases of alcohol, which brings pause for concern. Officer McCarson stated, bloodshot eyes. He didn't say the watery part. He said the strong odor of alcohol. And during the rendition of what the back and forth between them, the slurred speech was getting worse. This wasn't a 2 or 3 minute situation, Your Honor. Officer McCarson took it upon himself to, in a calm manner, explain everything, to the point that he was even explaining stigmatisms and talking about that because the defendant refused to exit his vehicle. The defendant did not want to do standard field sobriety tests, Your Honor. He didn't want to attempt them. As we look at State v. Sanchez makes it quite clear that the state can use evidence of a driver's refusal to consent to the standard field sobriety test to create an inference of the driver's consciousness of guilt. The investigating officer or an objectionable reasonable officer in his position could logically infer from the defendant's refusal to consent to the field sobriety test the defendant knew he was driving under the influence of alcohol and that the test may reveal his impairment. Your Honor, the window wasn't rolled down because guess what? If the window's rolled down where Officer McCarson was standing, you'd be able to see a case of alcohol in the passenger floorboard. The defendant wants to go to the VA because he understands, the state would argue, that the longer he is not having to do the breath test, the more that the test will reveal, not the less. Your Honor, the state does believe that they've met all the required elements necessary to find the defendant guilty, and we ask that you find him guilty on all 3 counts at this time.
So we are now at the beyond a reasonable doubt standard. That's the highest standard in the criminal justice system. The evidence can no longer be viewed in light most favorable to the state. It is the highest standard in the criminal justice system because this defense would say being accused of a crime is one of the greater affairs in life. So it is the state's burden to prove beyond a reasonable doubt all of these elements, all of these charges. And what is reasonable doubt? It's something that gives a reasonable person pause when deciding in the greater affairs in life. This is a greater affair in life. The state is attempting to convict Mr. Apodaca of a crime. But there is a ton that would give pause. There was a ton that would give a reasonable person pause before deciding whether or not Mr. Apodaca is guilty beyond a reasonable doubt. And now let's go through everything that would give someone pause when deciding these specific charges. First of all, open container. The state knowingly proceeded under subsection A, even when having a chance to amend. That chance is no longer there. Subsection A says, no person shall knowingly drink any alcohol while in a motor vehicle upon any public highway within the it would give a reasonable person a lot of pause to convict beyond a reasonable doubt without any evidence of consumption of alcohol. No one viewed him even having this container in his hand. It's in the vehicle. The state's trying to say because it's cold and it's open, he must have been drinking. But they're relying on the court to make that jump. They're relying on the court to speculate. If it's open, it must have been drinking while he was driving. Not before, not after, while he was driving. So it would give the reasonable person pause, Your Honor, to convict on that subsection beyond reasonable doubt without any evidence of it even being in his hand, much less of him consuming it while driving. Next, we have failing to maintain lane. Defense brought up that the law says a vehicle shall be driven as nearly as practical. We saw how much rain was on his vehicle. As nearly as practical should be modified when the conditions allow for it. If it's pouring, if it's snowing, one should not be punished or convicted when he's struggling to drive. But there's no testimony at all that he was not driving safely. There's just testimony that he crossed into the right lane and the left lane a couple of times. There's no testimony that he crossed all the way in, that he crossed all the way to the left. It could have been just a tire. It could have just been tires on both sides. And, Your Honor, as mentioned, State v. Siqueiros Valenzuela, 2017, NMCA 074 says it determines as nearly as practicable, and in that case, the defendant's tires did cross over the line, and it was still found that this momentary cross was not enough to violate the statute, Your Honor. And we don't have anything to say that it wasn't a momentary cross, given that he was struggling with the rain, he was struggling with his eyesight because of the rain. The state says, well, he shouldn't have been driving. There's no evidence that it wasn't clear until he started driving, then it poured, Your Honor. Driving in a rainstorm can be dangerous, but that is not evidence of impairment for the DWI, and for this charge, Your Honor, that would give someone pause when thinking about driving in a rainstorm, and as nearly as practical, with no evidence of him driving unsafely, Your Honor. So we'd ask that you find Mr. Apodaca not guilty of failing to maintain traffic lane as per 66-7-317. Now, Your Honor, in terms of the DWI, we'll start with the aggravated like last time. The state has made an argument that this independent test would have caused delay. Well, Your Honor, in the Implied Consent Act, delay is not to be considered. The state says, you have the right to an independent test, but if it's going to cause delay, who knows if the VA is open? Officer McCarson could have explained a blood test right then and there at the station. He could have called someone. It doesn't seem like Officer McCarson was interested in actually investigating, but had made up his mind for an arrest a long time ago, Your Honor. Took a refusal for a breath test as a refusal, when in all reality, Mr. Apodaca wasn't refusing a breath test. He was saying he wanted to do a blood test, which there's no other test that could more accurately depict the alcoholic contents of your blood than a blood test. And he agreed. The Implied Consent Act, as mentioned on at the directed verdict stage, says a person shall be deemed to have given consent to chemical tests of his breath or blood or both. And yes, blood is no longer an implied consent, but he gave his verbal consent. He chose a blood test. Officer McCarson refused and would rather just arrest him on the spot, Your Honor. So we don't believe, given that Mr. Apodaca wanted a blood test, or we do believe that given that Mr. Apodaca wanted a blood test would give a reasonable person pause before they decided whether he refused to give a test. The whole thing about giving a test is to determine the alcohol contents of your blood, and Mr. Apodaca wanted to take a blood test, Your Honor. Finally, in terms of the simple DWI, we'll start with the testimony from Sergeant Johnson. Sergeant Johnson gave a pretrial interview on February 2nd. The court heard this pretrial interview. They heard it was asked of him if he noticed any signs of intoxication. Sergeant Johnson said no, he did not. He also said he wasn't there to investigate. He was there to get him out of the vehicle, and Mr. Apodaca did voluntarily get out of the vehicle. But now we hear today, for the first time, almost 2 months later, that Officer Johnson did notice these de facto signs of intoxication, of bloodshot, watery eyes, slurred speech, and odor of alcohol, but not when he was directly asked, when he had an opportunity to give what he actually observed closer to the date of incident than today. So, Your Honor, I would ask that, given the impeachment, you do not give Sergeant Johnson's testimony much weight when it comes to those signs of intoxication. The reason I bring that up is because there's no breath test or blood test. We do not have a blood alcohol level, so defense is attempting to show that Mr. Apodaca was not impaired by alcohol. The state has to prove beyond a reasonable doubt that Mr. Apodaca was driving, that he was intoxicated to the point where he was impaired, and that those overlapped, and that's what defense would be attacking here, Your Honor, the impairment. Given that what defense argued on directed verdict, but now at the beyond a reasonable doubt stage, Officer McCarson says he noticed bloodshot eyes. There are many reasons someone can have bloodshot eyes, including the fact that it was after midnight. Could have been crying. Did not ask any follow-up questions to that, just noted bloodshot eyes. He noticed an odor of alcohol, and he attempted to say that it was coming from his breath. And, Your Honor, that's just not practicable here. As Officer McCarson said, the window was open that much. And as we can see on the lapel video, his mouth was not in the open area. He was in his seat. The window was open above him. There's no way to tell it's coming from his breath. It could have been coming from the container that was on the door, Your Honor. It was perfectly lined up to where that could have been where Officer McCarson was smelling the alcohol. But Mr. Apodaca did not admit to drinking. He said he was not drinking. Officer McCarson did not follow up. Perhaps he had alcohol spilled on him. Perhaps he was at an establishment that served alcohol, but he did not drink, and he didn't ask follow-up questions. He just assumed Mr. Apodaca was drinking. We say all that because it gives pause, Your Honor. It gives pause when deciding the greater affairs in life, which includes potentially convicting on a driving while intoxicated offense, because there's not enough evidence to show the state did not establish beyond a reasonable doubt that Mr. Apodaca was intoxicated. The state also relied on refusals. They also said in directed verdict that you cannot do standard field sobriety tests while sitting down in a vehicle. That's true, Your Honor. But when Mr. Apodaca got out of the vehicle, they did not ask him to do a field sobriety test. They arrested him on the spot. So we believe Officer McCarson made up his mind to arrest almost immediately. And we'd ask that you watch the video, and it's unclear if he was actually ever asked to just do standard field sobriety tests. We believe the video shows Officer McCarson asking, saying, he needs to investigate, and Mr. Apodaca saying he would not get out of the vehicle. But he did get out of the vehicle on his own volition and was not offered standard field sobriety tests at that. It would give a reasonable person pause to convict on a DWI when there's no evidence of standard field of performance in standard field sobriety tests, because defense believes he was not given an actual opportunity to do standard field sobriety tests when he was out of the vehicle. And potential bad driving that's explained away multiple times by Mr. Apodaca, that he was having a hard time seeing. He has bad eyesight, plus the rainstorm made it super hard to see. And it sounds like a dangerous condition, and it doesn't sound like he was intoxicated, Your Honor. That would give a reasonable person doubt. It would also give a reasonable person doubt that Mr. Apodaca denied drinking alcohol. There's no evidence other than what's in the vehicle. And what's in the vehicle could have been left out overnight. Could have been his mother's. I'm just speculating at this point. His wife's, his child's. There's no evidence to show that it was from him. It was drank before driving or while driving, Your Honor. So we ask that the court find the only possible outcome in this case and find Mr. Apodaca not guilty, as the state did not meet their burden of beyond a reasonable doubt in this case, Your Honor. And we ask that you find him not guilty of the aggravated portion and of the DWI itself.
Thanks.
Yes, Your Honor. As stated by the defense, Your Honor, gives a reasonable person pause. The state would also say a reasonable person is also a reasonable, logical person at this time, Your Honor. It's important to look at the situation surrounding what we saw today through the testimony of all the officers and the videos itself. The defendant refused to exit the vehicle. He wasn't in threat of his life whatsoever. Officer McCarson, Sergeant Johnson, and no point in time got aggressive, did anything else but explain the situation over and over and asked the defendant to exit the vehicle. Your Honor, we have standard field sobriety tests to test if somebody is intoxicated. We have breath tests to see what their alcohol content is. And we do this because the safety of the community is the top priority. An individual refusing to get out of a vehicle, rolling down his window only so far so that the officers could look inside, the state would argue is showing the consciousness of guilt, his fear of, one, if he performs those standard field sobriety tests, he's going to do poorly, and if he gives that breath test, they're going to see that he's intoxicated, that he cannot operate that vehicle safely. The defense wants to argue that the defendant eventually did exit the vehicle. Yes, but only after an additional officer was called, not one but two. This is pause for concern, because when an investigation for DWI starts, an officer needs to perform his investigation. So we have all the facts, we have all the evidence. We would have more today, both sides, if the defendant complied with the orders of Officer McCarson, but he didn't. What we see again, Your Honor, is when the defendant does exit his vehicle, we see an open container within reach to his left, and the open case of beer behind him, and one in his passenger floorboard. I'd like to also point out other things that the defense did leave out, such as Officer McCarson did state when the defendant was attempting to finally pull over after his extended period of time behind him, that he almost hit the median. That again, as defense states, it's a brief period of time for the fail to maintain lane, but it was two on each side. He went to the left twice, crossed, and to the right crossed. This is concerning. The law and the statute is clear. Maintain your lane as practical as possible, and that is safety. And especially when it's raining, that's what needs to happen. Your Honor, looking at the evidence that's laid out before the court, the defendant refused lawful orders to exit the vehicle. When Officer Johnson and Sergeant Johnson and Officer McCarson explained what was going on, before they could even ask, the defendant said, "I refuse to do these tests. I don't want to do anything. I will have my wife come and pick me up. Why can't you just leave me? Look, we'll work this out. I'll have my wife come pick me up." That's not how this works. If we let people dictate, defendants dictate, then we have a larger issue at hand. It means the officers, such as McCarson with 31 years experience, thousands of DWI arrests, cannot do their job. I understand the defense's position of the blood test, but the Implied Consent Act is clear. It's the test that the officer requests, and then the follow-up test is the one that they can request. He could have requested a blood test, as he did, but it's the second test. The breath alcohol test needed to be conducted. He was right next to the intoxilizer, and he refused. Not saying yes is the same as saying no in that situation. This does not need to be confused. As defense said, a reasonable person to give pause, it would give a reasonable person pause to see an open container within arm's reach to somebody on the open highway in the state of New Mexico. It would give someone pause that someone refuses to exit their vehicle, rolls down their window only 2 inches, and when we open up the vehicle, it would give anybody pause to see all of that alcohol, and a defendant, again, refusing to exit, where 2 officers had to go and talk to him, and there had to be a 3rd support officer. Your Honor, the state asks that you find the defendant guilty of all counts today. Thank you.
Okay, thank you, parties. Okay, let me take a brief look at my notes, and I will give you a ruling. Okay, thank you, parties. We've heard testimony from 3 officers today. Not only has the court heard testimony from 3 officers, but the court also was able to see portions of the video that Officer McCarson ran on that date. First of all, let me get to my proper notes. When it comes to failure to maintain a traffic lane, Officer McCarson testified that he saw the defendant driving go 2 times to the right, then 2 times to the left. There was testimony that it was raining. I could see on the video that it was raining quite a bit on that night. It was dark, and heard the officer's testimony that Mr. Apodaca did not pull over his vehicle immediately once Officer McCarson turned on his emergency lights. based on the testimony from Officer McCarson that Mr. Apodaca went to the right a couple of times, went to the left a couple of times, that tells me that Mr. Apodaca was not trying to stay within his lane as nearly practicable as possible. He was going back and forth between the right lane and the left lane, and so I'm finding Mr. Apodaca guilty of failure to maintain a traffic lane. When it comes to the DWI charge, it is concerning to the court that Mr. Apodaca was exhibiting this type of driving at night in the rain, took a long time for him to pull over, didn't pull over immediately when Officer McCarson turned on his lights. Then when Officer McCarson did approach his vehicle and to talk to Mr. Apodaca, I could understand that he didn't want to pull his window down very far because of the rain. There was a lot of rain. Officer McCarson said he rolled his window down about this much. That's what I saw Officer McCarson pick up his hand and show this much. That, to me, that's more like 3 inches, at least 3 inches. And I could understand him not rolling it down all the way, but to me, it seemed like Mr. Apodaca was not willing to be cooperative on that night with Officer McCarson. Officer McCarson has extensive experience and training, and the court has to rely on his experience and training and his observations on that night. A video can tell us some things, but a video cannot tell us everything. Seeing the defendant's behavior and uncooperativeness with Officer McCarson is really concerning because the officer is there to do his job. I would have expected Mr. Apodaca to cooperate more, to be willing to talk to Officer McCarson more and cooperate with the investigation. But Mr. Apodaca did not want to do that. I understand that Mr. Apodaca was trying to give him an explanation about his driving and his vision and those types of things, but it just came down to him not being cooperative. Also, it seemed to the court that Mr. Apodaca did want to avoid too much direct contact with the officer by the fact that he wouldn't exit his vehicle, the fact that he wouldn't roll down his window more than he did. Officer McCarson said he could smell the strong odor of alcohol. I have to believe Officer McCarson. He said, this defense stated that the window was only rolled down this much. I don't agree. Officer McCarson said it was rolled down this much. And so even though the window wasn't rolled down as much as Officer McCarson would have liked, Officer McCarson stuck by his testimony that he smelled a strong odor of alcohol. I have no reason not to believe Officer McCarson's testimony. I have no reason not to believe he's a credible witness, so I am relying on that. And after a significant amount of time of Officer McCarson trying to get Mr. Apodaca to exit the vehicle, explaining to him that he would do field sobriety tests and needed to do his investigation, after going round and round with Mr. Apodaca. And I believe I believe Officer McCarson was being as patient as he could be under the circumstances. I think that he was patient. I think that he worked really hard not to escalate the situation so that it turned into something else. But at the same time, I think Officer McCarson was concerned that Mr. Apodaca could drive off at any moment. And he was concerned about the safety of the public. So Officer McCarson had no choice but to call out for assistance. Sergeant Johnson appeared and Officer Wilson as well. I'm not giving much weight to Sergeant Johnson's observations of any clues, as he did not write a police report, and his testimony might not have been consistent with information he gave at a pretrial interview. So I'm not giving much weight as to any clues that he might have seen or observations he might have seen. His sole job, as what he stated in his testimony, was to assist Officer McCarson because the defendant refused to exit his vehicle. The defendant is, so based on the totality of the circumstances for the DWI, there was bad driving, there was a refusal to cooperate with investigation, there was failure to obey lawful orders of an officer, strong odor of alcohol, and I haven't gotten to the open containers yet, but there was, once the defendant did exit the vehicle and an inventory search was done, there was an open container found to the very left of the defendant in the vehicle within arm's reach. And all of that taken into consideration, the court believes that defendant was driving while intoxicated and was impaired to the slightest degree by alcohol. Mr. Apodaca had an opportunity to submit to standard field sobriety tests. I think Officer McCarson went into what his investigation would entail, but Mr. Apodaca was not going to cooperate, and that's what I could see from the video, is that there was just no way Mr. Apodaca was going to cooperate. I think it took another two officers arriving on scene, and Sergeant Johnson pleading with Mr. Apodaca to not force them to drag him out of the vehicle and not to escalate the situation, and to be reasonable and comply with their orders. So, you know, all of that taken into consideration, I believe there was impairment, and there was impairment by alcohol, including the bloodshot eyes, strong odor of alcohol, and I believe Officer McCarson did hear slurred speech. I'm relying on his extensive experience and his training, doing over 3,000 DWI investigations, and so I rely on his observations and his testimony for that. As to the aggravated portion of the DWI, as to the aggravated portion of the DWI, Mr. Apodaca, yes, may have offered to do a blood test, but the defendant does not get to choose the type of test he wants to perform, what kind of chemical test. The defendant must submit to a test of the officer's choosing. Officer McCarson read the Implied Consent Act. He didn't read it, I'm sorry. He had it memorized and stated what the Implied Consent Act requires, including telling Mr. Apodaca that he had the right to an independent test and that APD would pay for that test as well. I am finding Mr. Apodaca guilty of the aggravated portion of the DWI as well. If Mr. Apodaca wanted a backup test, he was advised he could have had an outside agency perform an independent test, and APD would pay for that. As to the open container charge, I am finding Mr. Apodaca guilty as well. That open container was found in the door of the vehicle on the driver's side, within reach. It was cold to the touch, and one can presume that he was drinking either while he was driving or Well, it can be presumed that he was drinking while he was driving, and he had that in the vehicle. There was a strong odor of alcohol, and the court believes that he is guilty of open container as well. And there was a testimony given about where the open container was. It was also listed in the tow sheet, and I'm finding that based on all of the testimony, the video, totality of the circumstances, and I'm finding that beyond a reasonable doubt, Mr. Apodaca is guilty of aggravated DWI. First offense, failure to maintain a traffic lane and open container, and that he was impaired to the slightest degree by alcohol. Okay, Mr. Apodaca, at this time we can go ahead and proceed to sentencing. Parties, are you okay with that?
Your Honor, can we have a few moments to speak with our client about matters concerning the ruling and a potential appeal?
Okay, and let me just advise you, Mr. Apodaca, you have 15 days to appeal my ruling. I would give you an ROR appeal bond. We can proceed to sentencing unless the state wants to request a pre-sentence report.
Yeah, the state would be requesting a PSR.
Okay, so state is requesting a pre-sentence report. Defense?
Your Honor, defense is fine with the pre-sentence report.
Okay, so why don't we go ahead and I will enter my ruling, and I will order a pre-sentence report, and the probation will set this for a sentencing date. Mr. Apodaca, you will have to report to probation for intake, or so that they can interview you, so that they can prepare a pre-sentence report. So you'll have to comply with that. Make sure that you, we'll give you instructions of what you need to do and the phone number you need to call. You'll make an appointment with them. They'll interview you. They'll prepare the report, and they will also set this for a sentencing date. I imagine it would be 2 to 3 weeks out. I'm not sure the timeline of that.
Your Honor, we specifically ask for him to be pre-screened for, or potentially for Veterans Court, as he does qualify for Veterans Court.
I think that once the pre-sentence report is prepared, he will be screened for all programs. So I believe that's the process that they do. Oh, do you believe that he was already screened?
Yeah, he was already screened. They'll put it on there, though.
Okay, so they'll be alerted, and I'm sure his name will come up, and that's something that if he was already eligible, then who knows, there might be a pre-sentence report that has already been prepared or partially prepared. I don't know if that's true or not, but we'll have to see. Okay, I'll go ahead and enter my order and order Mr. Apodaca to report to pretrial services to have that pre-sentence report prepared. Is that the same? 8189, yes. Okay, thank you, parties.
Thank you.
Can you put me on mute?